So yesterday we had started with this special status of Delhi. In fact, we have completed our discussion on this very idea. We had seen yesterday that the 69th Constitutional Amendment Act in 1991, through the 69th Constitutional Amendment Act, we have introduced this very provision, that is we have introduced Article 239AA of the Constitution and Article 239AB of the Constitution by the 69th Constitutional Amendment Act. Now, this Article 239AA of the Constitution basically does what? It establishes a legislature for the National Capital Territory. For the National Capital Territory, that is the UT of Delhi, is now designated as the NCT of Delhi. Now it is designated as the NCT of Delhi. This legislature, from this legislature, there are Council of Ministers headed by the Chief Minister. The office of the Council of Ministers headed by the Chief Minister is established. The Council of Ministers and the Chief Minister, they are appointed by the President. So the Chief Minister is appointed by the President, not the Lieutenant Governor. Not the Lieutenant Governor. Now this is what is different. If you compare other states to that of NCT of Delhi, in other states the Chief Minister is appointed by the Governor. Here the Chief Minister is appointed by the President. The other Council of Ministers are appointed by the President on the recommendation of the Chief Minister. By the President on the recommendation of the Chief Minister. Article 239AA of the Constitution also says that Part 15 of the Constitution, which deals with the elections, and Articles 324, 325, 326, 327, 328 and 327 and 329. This is extended to the UT of Delhi. Article 328, which deals with the power of the power of the state legislature to make laws, that power is not there with the legislature of Delhi. Similarly, the provisions also say that the Council of Ministers, the maximum strength of the Council of Ministers is 10% of the legislature of the NCT. Now this is also different from the other provisions, that is, in other states it is 15% of the state legislative assembly or 12, whichever is higher. Whichever is higher. In the case of Delhi, it is not, it's not 15%, it is 10% of the legislative assembly here, and this means that in Delhi maximum of 7 council of ministers can be appointed. Maximum of 7 council of ministers can be appointed as one will be chief minister and there will be other 6 council of ministers. Why? Because the legislature of Delhi has a maximum strength of 70 members. These 70 members, all of these 70 members are directly elected. All of these 70 members are directly elected. Clear? All of these 70 members are directly elected. Clear? Now, Article 329AA of the Constitution also establishes a position of the Lieutenant Governor. Of the Lieutenant Governor. This individual previously the administrator of Delhi, this position has been replaced by establishing a position of the Lieutenant Governor. Now if you look at the UTs, in all UTs you will find that there is a position of an administrator. Only those UTs which have a legislature, only those UTs which have a legislature, only in those UTs we have a position of a Lieutenant Governor. Clear? And for the very first time this position was established where? It was established for the NCT, National Capital Territory of Delhi. Now this position is very similar to the office of the governor in all the states. However, the Lieutenant Governor also exercises some other powers, like, I'm just rubbing this off. Under Article 239AA of the Constitution, it says that the Lieutenant Governor will be given aid and advice by the Council of Ministers headed by the Chief Minister, and they will provide aid and advice to the Lieutenant Governor, except for those cases or in those areas where he is supposed to act in his discretion. Where he is supposed to act in his discretion. Further, Further, it also says that the Council of Ministers and the Lieutenant Governor, if there is a difference in opinion, that means the aid and advice that is tendered by the Council of Ministers to the Lieutenant Governor, if there is a difference in opinion on that aid and advice, the Lieutenant Governor will refer the matter to the President and will act accordingly. Which means if there is a difference in opinion, the matter is referred to the President. And whatever is the decision of the President, that decision will be implemented. So if the President agrees with the Council of Ministers or the President agrees with the Lieutenant Governor, so whatever is the decision of the President, the decision of the President will prevail. The decision of the President will prevail, and accordingly it will accordingly be acted upon. Except for any urgent, when there is any urgent requirement, in that case the Lieutenant Governor will act according to how he deems necessary. That means if there is an urgent condition, according to the Lieutenant Governor, if there is an urgent condition that appears, in that case, when the Lieutenant Governor cannot wait for the advice of the President, then it will be the decision of the Lieutenant Governor which will prevail over the decision of the other Council of Ministers. It will be the decision of the Lieutenant Governor which will prevail over the decision of the Council of Ministers. Clear? So he will act in the manner he deems necessary. Clear? Absolutely clear? Article 239AB. This deals with the power of the Lieutenant Governor to invite the President to assume the functions of the state executive on breakdown of constitutional machinery. Breakdown of constitutional machinery. Like other states under Article 356 of the Constitution, where the governor, if the President is satisfied on the report of the governor or otherwise that there has been a breakdown of constitutional machinery, then the President can assume the executive powers of the state. Similarly, under Article 239A(b) of the Constitution, the President can assume the executive functions of this NCT, National Capital Territory, by dismissing the Council of Ministers on the grounds of breakdown of constitutional machinery. on the grounds of breakdown of constitutional machinery. And now we already have discussed what is the meaning of breakdown of constitutional machinery. So I will not be repeating it again. You know what is the meaning of breakdown of constitutional machinery. Clear? Absolutely clear. This is what is the special status. One more thing. The legislature of the NCT has the power to make laws on any items mentioned in the state list or concurrent list under the 7th schedule except item number 1, 2 and 18. 1, 2 and 18, which deals with public order, police and land. Public order, police and land. The legislature of the NCT of Delhi has the power to make laws on any item mentioned in the state list or concurrent list, on any item mentioned in the state list or concurrent list of the 7th schedule except for item number 1, 2 and 18, which deals with public order, police and land. Public order, police or land. And that is the reason why you will find that when we talk about the Delhi police does not fall under the jurisdiction of the state, or what you can say the Council of Ministers of the NCT of Delhi. They do not fall under the jurisdiction of the Council of Ministers of Delhi. Delhi police in India is administered directly. Delhi police is administered directly by the union. Why? Because police is not under the jurisdiction of the Council of Ministers, or for that matter the state, the NCT legislature. They cannot make laws with respect to police. They cannot make laws with respect to public order. Any item that is mentioned as a part of public order, or for that matter land. They are outside the jurisdiction of the NCT. This is not the case when you look at other states. In other states, the full-fledged states that are there, these full-fledged states, in these full-fledged states, the state government and the state legislature has jurisdiction over these 3 items, that is police, public order and land. It belongs to the state legislature and to the state government, the state executive. In NCT of Delhi, it belongs to the union government and not to the state government. Clear? So the land that is there, in this case, in case of land, you can, the state, the NCT of Delhi cannot take any kind of decision. Recently you must have heard about, and because there in Delhi elections are due, in that case you must have heard about it, or you must have seen hoardings with respect to unauthorized colonies. The decision has been taken to authorize them. Now this decision is taken by the central government, not by the NCT, not the government of the NCT. They cannot take this decision. It is completely over the central government to take any such decision. Clear? Police does not fall under them, public order does not fall under them, and so does land. Land also is not under the jurisdiction of the NCT, the government of NCT and the legislature of NCT. Clear? This is the special status or not so special status of Delhi. Clear? It is, it says the special status basically means it is a UT with legislature. The special status means that. And generally union territories that are there, they are administered directly by the central government. They are administered directly by the central government through the office of an individual, through this office of an administrator. This administrator is an individual who is appointed by the President of India. So, if you look at other UTs without legislature, you will find that they are directly under the union government. But when it comes to this National Capital Territory, this region that is there, NCT, this particular region falls under the, they have a legislature, they have an executive, so they are relatively autonomous except for the fact that these three items which are mentioned as a part of state list, this is not present with the state government or the government of NCT here. Clear? This is all about the special status of Delhi. Clear? We have completed this. Now we move to our discussion on judiciary. Let's start. Give a subheading, write judiciary. President will not act on the... No. President does not have any discretion. President will always take the decision in accordance to the advice that is given by the Union Council of Ministers. Let's start with the judiciary. See, in India, when we talk about the judiciary in India we have what is called as a single and unified judiciary. Single and unified judiciary. That means if you compare this provision to that of a ideal federation like that of US, in United States this is not the provision, and there the judicial system that is there, their judicial system, it works autonomously and it is not single and unified. Now what is meant by this idea of a single and unified judiciary? It means that judiciary in India is organically linked. This is organically linked and hierarchically organized. Organically linked and hierarchically organized. It is organically linked and hierarchically organized. When we say it is organically linked, what is the meaning of organically linked and what is the meaning of hierarchically organized? Hierarchically organized means in India we have the Supreme Court, and below the Supreme Court we have the High Courts, and below the High Courts we have subordinate courts. Now the Supreme Court exercises administrative jurisdiction over the High Courts, and the High Courts the High Courts have jurisdiction over the subordinate courts. This is meant by hierarchically organized. This means, see, this is the subordinate court. Then administratively speaking, if you look at hierarchy, the hierarchy dictates that there will be a High Court, and the High Court does what? It exercises jurisdiction over the subordinate courts. That is also the case with the Supreme Court. The Supreme Court does what? The Supreme Court exercises The Supreme Court exercises jurisdiction over the high courts. This is meant by what? No, this is what is meant by hierarchically organized. When we say organically linked, what is meant by organically linked? The judges of the subordinate court, they are what you can say promoted to being the judges of the high courts, and the judges of the high courts are promoted to being the judges of the Supreme Court. So when we say organically linked, how are they organically linked? They are organically linked through this particular mechanism. The judges that are there in India, if you see the recruitment of judges, we are very much coming to that idea. You will find that the recruitment of judges in India that takes place, it takes place on this particular basis. That is, it is at the lowest level when there is a direct competitive examination that is held, and in this competitive examination, anyone who qualifies will become the judge of the subordinate court. Will become the judge of the subordinate court. Once an individual is now under this, now he is the judge of the subordinate court. Now he is the judge of the subordinate court. After a certain years, he may be appointed as the judge of the high court. If he is promoted, then he is promoted to being the judge of the high court. Once he serves a certain tenure under the judge, under the high court, then he becomes the judge of the Supreme Court. This is how it goes on. If you look at the constitution does not mention this. The constitution mentions, yes, the members of the subordinate court that are there, they are to be appointed by the governor and through the, in consultation with the Public Service Commission. This is what is mentioned. If you look at the qualifications to be the judge of the high court, it just says that you should be a citizen of India and you should have served at least 5 to 10 years as a lawyer. It does not say that you have to be a judge in the subordinate court. It does not say that. It just says that you have to have this qualification that you have been a practicing lawyer for at least 10 years in the concern, in some high court. If you have this qualification, you can be appointed as the judge of the high court. It just says this. It is just saying this. It does not say that there will be some kind of competitive examination or something like that. No, you are promoted from subordinate courts to become the judge of the high court, and then you are promoted from high courts to become the judge of the Supreme Courts. So judiciary in India, we say it is single and unified, and it is organically linked and hierarchically organized. What is meant by organically linked and hierarchically organized is this: the Supreme Court of India exercises administrative control over the high courts, and the high courts exercise administrative control over the subordinate courts. This is what is meant by hierarchically linked. How are they, hierarchically organized? How are they organically linked? The judges of the subordinate court are promoted to being the judges of the high court, and the judges of the high court are then promoted to being the judges of the Supreme Court. This is how they are organically linked. Clear? Now, when we say single and unified judiciary, this is not the case with other federal countries, or more importantly, if we consider a federation like US, that is not the case. Why? Because in US, every state has its own Supreme Court. Every state of US has its own Supreme Court, and the Supreme Court is completely autonomous there. It does not work under the jurisdiction of a federal court. There is a court at the what you can say union level also, at the federal level also. It is called as the federal court. It's not called as the Supreme Court. It is called as the federal court. Constitutionally speaking, it is referred to as the federal court. And in this federal court, this federal court does not exercise any jurisdiction, any administrative or hierarchical jurisdiction or control over the state Supreme Courts. They do not enjoy that kind of control. Clear? If you look at the appointment that is done, The appointment that is done in the in the judicial system there has nothing to do with the kind of system that is followed in India. There, the president of India, the president of US can appoint any individual with some legal qualifications to becoming to being the judge of the federal court. It is completely up to the president. The president does that, and yes, the Senate, that is the upper house, ratifies it. But it is completely up to the president, and the ratification that is done by the Senate, it is more nominal in nature. Any individual who is who is appointed by the president automatically gets the ratification of the Senate. There, this is not the provision. In fact, there, if you look at the subordinate courts, interestingly, in US, the judges of the subordinate court are elected. The judges there are elected. They are not, they do not enter this through a competitive examination. Once an individual holds a legal degree there, he can contest election to become the judge. So there they follow a very unique idea of election of judges. They follow a very unique idea of election of judges. There are a lot of problems with that particular system, but this is what is followed there. Now this is what is followed there, election of judges. So at the lowest level there are individuals who are elected, and then when it comes to the Supreme Courts at the state level and the federal court, at the federal court it is completely up to the president. The president nominates the judge, nominates any individual to become the judge of the federal court. And when it comes to the Supreme Court at the state level, it is completely up to the governor. No, it is up to the governor. Clear? So if you look at the system there, the judicial system is not unified as the case is in India. This is also a unitary feature. It's not a federal feature, because you can find the judges of the High Court are they are promoted to being the judges of the Supreme Court, and the Supreme Court exercises administrative control over the High Courts. This is not a federal feature. It is a unitary feature, and the unitary tilt that we have been talking about is so much very visible when we talk about the single and unified judiciary as well. Clear? Have you understood this idea? Now give a subheading, right? Functions of the Supreme Court. Give a subheading, right? Supreme Court. First, let's start with the Supreme Court. And below that, write functions of Supreme Court. Functions of Supreme Court. First function, to act as the custodian of the Constitution. To act as the custodian of the Constitution and helps in maintaining its supremacy. Helps in maintaining its supremacy. Second, it acts as the federal court. It acts as a federal court where it is the sole arbitrator. Where it is the sole arbitrator of disputes arising between center and states, or between states on the question of division of power. Third, it acts as the protector of fundamental rights. Guaranteed by the Constitution. Fourth, it also plays the role of a consultant. to the president where it expresses its opinion on any issue of law or fact that is in public interest, referred to the Supreme Court by the President. And fifth, it is the highest court of appeal. It is the highest court of appeal in the country, and its decisions are automatically binding on all other courts. Now see, if you look at the first function that is performed by the Supreme Court is said to act as the custodian of the Constitution, to maintain the supremacy of the Constitution. And how does the Supreme Court do this? Yes? Under Article 13. But Article 13 only deals with fundamental rights. Yes? That also deals with only fundamental rights. Yes? That is Article 32 of the Constitution. The phenomena is judicial review. See, the idea of judicial review, it has not been explicitly mentioned in the Constitution anywhere. And we say yes, implicitly it is derived from Article 13 and Article 32 in case of Supreme Court, and Article 226 in case of High Courts. Because that deals with, Article 13 deals with the pre and post constitutional laws that are to be held unconstitutional or void if it is violative of one or more fundamental rights. And Article 32 of the Constitution imposes a duty on the Supreme Court to protect the fundamental rights of all citizens. This is what is mentioned. This is what is mentioned under Article 13 and Article 32. So yes, we say that Article 13 and Article 32 implicitly talks about the idea of judicial review. But the concept of judicial review, when we talk about the supremacy of the Constitution, how does the Supreme Court maintain the supremacy of the Constitution? It is through the phenomena of judicial review. And judicial review is not practiced by the Supreme Court only under Article 13 and Article 32. Because Article 13 and Article 32 of the Constitution deals with fundamental rights. But the Supreme Court has done what? The Supreme Court, through under various mechanisms, has come out with various factors, and we consider them to be certain things that are very important for the governance of the country. It is considered to be like a basic provision of the Constitution, which is called as the basic structure. And the Supreme Court has declared that there are certain provisions which are the part of basic structure of the Constitution, and it cannot be violated. So how does the Supreme Court maintain? How does the Supreme Court maintain the supremacy of the Constitution? The Supreme Court maintains the supremacy of the Constitution by performing judicial review. So it takes up various, various laws that are made by the legislature. It takes up various acts that are performed by the executive and sees whether those laws are contradictory to the provisions of the Constitution or not. If the acts or the laws that are taken up, if it is considered to be contradictory to the provisions of the Constitution, it is declared as unconstitutional and void. Ultra vires, if you remember, which means non-enforceable. It is not to be enforceable. And based on our discussion, see, we have discussed almost everything under the Constitution. We have discussed fundamental rights, we have discussed, directive principles, we have also discussed other aspects, judicial, we have discussed the legislature, we have discussed the executive, union executive, state executive, we have discussed all of these provisions. Now we have discussed bills, etc., and we have seen that laws are challenged on the, in the Supreme Court, not just on the grounds of it being violation of the fundamental rights. It is challenged on the grounds of its constitutionality, not just because it is a violation of fundamental rights. Not just because it is a violation of fundamental rights. Some of the laws that are made by the legislature, some of the acts that are performed by the executive, they are challenged on the grounds of its constitutional validity, not necessarily because it is always a violation of fundamental rights. Not always because of that. So, the maintenance of the supremacy of the Constitution, who performs this function? It is the Supreme Court. It is finally the authority lies with the Supreme Court to ensure that the Constitution becomes the supreme document rather than any power that is derived by any agency from the Constitution. Not the agency, rather it is the Constitution which is the supreme document, and it is ensured by the court. Like we are going to just now itself, we are going to talk about the appointment of judges of the Supreme Court, and you will find that around 2014-15, in 2014-15, there was a constitutional amendment that was passed. That constitutional amendment talked about creating a body called as the Judicial Appointments Committee, NJAC, National Judicial Appointments Committee. And this National Judicial Appointments Committee, constitutional amendment was done. The Supreme Court declared this constitutional amendment to be ultra vires, that is unconstitutional and void. Why? What was the ground? According to the Supreme Court, it took away the independence of the judiciary. So it did not violate fundamental rights. It was not violative of any of our fundamental rights, but it was still held to be unconstitutional. So when we say, how does the Supreme Court ensure? How does the Supreme Court ensure the supremacy of the Constitution? The Supreme Court ensures the supremacy of the Constitution by performing the phenomena of judicial review. Clear? Second, what is the second function that we see? Second function is that it acts as a federal court. Now, what is meant by federal court? Like we have already seen, in US the judicial system is different. Every state has a Supreme Court, and then there is a Supreme Court or a federal court at the central level. Now when we talk about this particular federal court in US, what is the basic function that this particular court has? You will find that the basic function that this particular court has is to administer to adjudicate any dispute that comes up between the federal government and the state government there. So when there are when there are some constitutional issues that crop up, or when there is a dispute between two of the states there, or between the federal government and the state government, all these disputes are adjudicated where? It is adjudicated at the federal court, in the federal court of US. It is adjudicated in the federal court of US. In India, this is an additional responsibility that the Supreme Court has. So not only the Supreme Court is responsible for maintaining the supremacy of the Constitution, the idea of acting as a federal court, the power, the authority to act as a federal court in India also lies with the Supreme Court. It also lies with the Supreme Court. So when it comes to any matter that is referred, any matter that has to deal with any kind of dispute that arises between the center and the state, or between the states themselves, any kind of matter that arises there, who adjudicates those disputes? It is done by the Supreme Court. Third, the Supreme Court also acts as the protector of fundamental right. Now, under which constitutional provision does the Supreme Court act as the protector of fundamental right? Article 32. See, the protector of fundamental right. Who is the protector of fundamental right? Article 32 says it is the duty of the Supreme Court to protect the fundamental rights, not the duty of the High Court, not the duty of the subordinate court. The duty lies with the Supreme Court. So, who is the protector of fundamental rights? It is the Supreme Court which acts as the protector of fundamental rights. It is the Supreme Court which acts as the protector of fundamental rights, not the not any other court. Clear? Next, it also plays a role of the consultant to the president. So you will find we are going to come to jurisdiction, and there is something called as advisory jurisdiction of the court. No, advisory jurisdiction of the Supreme Court. And what does the Supreme Court do? If the president feels that in public interest there is a matter which is in public interest, and there is a question of law or fact, that means there is a legal question that is there, or for that matter there is a factual question that has arisen. In that case, the president can refer that matter to the Supreme Court. The president can refer the matter to the Supreme Court, and accordingly the Supreme Court can advise the president on it. Advisory jurisdiction. So the president can be advised by the Supreme Court on certain matters. Like you must have heard about recently about something called as a mercy petition. Okay, news mein aapne, you must have read about this because of the Nirbhaya case that was going on, and finally the hanging, the capital punishment has to be taken up on 1st of February. Initially it was to be taken up on 22nd of January, but later on, because of a petition that was filed by one of the convicts, a new date has been decided, that is 1st of February. 1st of February. Now, if you have gone through the powers of the president, the judicial powers of the president, you would have read one of the power that the president has is to do what? Is to hear such petitions. And if the president wants, the president can provide, as the name suggests, mercy petition. So the president can do that also, give mercy. So an individual who is to be who is to be punished from he is being given capital punishment, the president can do what? Change the nature of punishment, or the president can commute the punishment, or the president can pardon an individual. So pardoning an individual means what? The completely free. He is to serve he does not have any legal liability then. Commuting, what does that mean? Change the nature of sentence from capital punishment to life sentence. Or for that matter, the president can even do what? The president can even sometimes change the the duration of punishment. So for suppose life sentence can be commuted to 7 years, 10 years, whatever. The president has that power. Sometimes in deciding certain cases, the president, if he requires a clarity of fact, while taking such a decision, if the president requires clarity of fact, in that case the president can refer the matter to the Supreme Court, and the Supreme Court will advise the president that this is the case. Advisory jurisdiction, because it is an advisory jurisdiction of the court, whatever advice is tendered by the Supreme Court to the president, it is not binding on the president. It is not binding on the president. It is only an advice. It is not an order of the Supreme Court. Any advice that is given by the Supreme Court under this provision, when the president has asked the court to advise, it is not binding on the president to follow such an advice. It does not become mandatory or binding on the president. What happens? The president can or may not act in accordance to the advice given by the Supreme Court. In certain cases, advices given by matters referred to the Supreme Court is mandatory. In certain cases, the Supreme Court can choose that it can choose a matter for not advising also. It can reject it also. Like anything that is pre-constitutional in nature. In that case, if the matter is referred to the by the president to the Supreme Court, it is mandatory for the Supreme Court to give advice. Mandatory. Anything that is post-constitutional, it is not mandatory. Even if the matter is referred by the president to the Supreme Court, the Supreme Court will deny, no, I will not interfere in this matter. It can be done by the court. Anything pre-constitutional, mandatory. Anything post-constitutional, not mandatory. So that is called as advisory jurisdiction of the Supreme Court. And the Supreme Court does what? The Supreme Court also acts as the highest court of appeal. The Supreme Court also acts as the highest court of appeal. Any matter that is there, that is going on in India, because courts in India are hierarchically linked. So if I am not happy with the decisions of the subordinate court, I can appeal in the High Court. If I am not happy with the decision of the High Court, I can appeal in the Supreme Court. But the Supreme Court, once the Supreme Court has given its jurisdiction, it automatically becomes binding on all the other courts to actually abide by the decision of the Supreme Court. To abide by the decision of the Supreme Court. Clear? So it is the highest court of appeal. In India, the Supreme Court is the highest court of appeal. So if you look at what are the functions that it performs these functions. Clear? Understood this? Have you understood this idea? Now, give a subheading and write appointment of judges. Under Article 131 Federal Court, not necessarily. That is original jurisdiction of the court. So, original jurisdiction, yes, you can say original jurisdiction of the court, it acts as a federal court there. But there are some other provisions also, not necessarily just. But yes, primarily speaking, it is a federal court because of what Article 131 of the Constitution has to say. Appointment of judges. Now, this is a very important aspect of our discussion. So, when we see the appointment of judges, if you look at Article 124 of the Constitution, Article 124 of the Constitution, Clause 1 itself says that the Supreme Court shall consist of the Chief Justice and number of such puisne judges. Puisne judges means other judges, other than the Chief Justice of India. And every judge of the Supreme Court, including that of the Chief Justice of India, is to be appointed by the President. And when it comes to the Chief Justice of India, the Chief Justice of India is appointed by the President, and other judges of the Supreme Court is appointed by the President on the consultation with the Chief Justice of India. If you look at Article 124 Clause 1 and Article 124 Clause 2, this is what is mentioned in the Constitution. What does it say? Article 124 1 Clause 1 says that there shall be a Supreme Court which will have a Chief Justice of India and number of other puisne judges. Puisne judges means other judges. Clear? And Clause 2 says that the Chief Justice of India will be appointed by the President and other judges of the Supreme Court will be appointed by the President on a consultation with the Chief Justice of India, CJI. Clear? This is what is the constitutional provision. But this is actually not how the judges are appointed in India. The manner in which the judges are appointed in the, in India, the judges of Supreme Court are appointed and the judges of High Court. How are they appointed in India? It has undergone an evolution. It has undergone an evolution, and initially, that is, if we see till the 1980s, this was the simple provision. Now, it was a simple provision that it was the President of India who appointed the judges, and President of India appointed the Chief Justice of India, and any other judge that he had to appoint, the President had, President appointed the appointed those judges in consultation with the Chief Justice of India. And till the 1980s, this was something that was followed. However, the constitutional evolution here has underwent what is called as 3 cases. The first judge case, the second judge case, and the third judge case. And through this constitutional evolution, what we have done is we have come across something called as a collegium system. And through this collegium system, now the judges that are appointed to the Supreme Court, they are appointed through a collegium system, the manner in which the collegium works. So, what are these 3 judge cases? This is the most important part of our discussion here. Let us see them one by one. First, what is the constitutional provision here? Write that. Appointment of judges. The Constitution of India provides for, under Article 124, Clause 1, that there will be a Supreme Court consisting of 1 Chief Justice of India, 1 Chief Justice of India, and 33 puisne judges. 33 puisne, P-U-I-S-N-E, puisne judges. Puisne judges. Currently, then, what is the strength of the Supreme Court? 34. 1 Chief Justice plus 33 puisne judges. See, you can underline this. Actually, check this. It may so have happened that this was increased. So, it is either 33 or 36. Please check. But the current strength is 34 judges. Whether additionally they have been appointed or not, that is constitutional amendment has been made or not, that is something that is to be seen. But currently the strength is of 34 judges. 1 Chief Justice of India plus 33 puisne judges. The Chief Justice of India is appointed by the President, where the President can consult such judges of Supreme Court or High Court, as he deems necessary. So, in appointment of the Chief Justice of India, it is completely up to the President. The President may do what? The President may consult any number of judges that he deems necessary. So, if he wants, he can consult number of them. If he does not want, he will not consult any of the judges. Clear? This is what is the Constitution saying. Next. However, while appointing other judges, the President shall consult the CJI, Chief Justice of India. We are going to refer to this office as CJI, the Chief Justice of India. Clear? So what does the Constitution say? President appoints both of them, that is Chief Justice of India and other judges. While appointing the Chief Justice of India, the President, if he wants, he can consult any number of judges from Supreme Court and High Court. Whereas while appointing the other judges, it is mandatory for the President to consult the Chief Justice of India. Clear? Next paragraph. Next paragraph. In the SP Gupta versus the Union of India, SP Gupta versus Union of India 1982 case, Union of India 1982 case, the Supreme Court held that the consultation with the CJI, under Article 124 Clause 2, 124 Clause 2, 217 Clause 1, 217 Clause 1 and 222 Clause 1, 222 Clause 1 was not binding, but the consultation must be effective. The consultation must be effective. That is, all material facts relating to the person under consideration for appointment or transfer should be made available to the CJI, in brackets here mention the first judge case. The first judge case. See, the first judge case, the name of the case is SP Gupta versus the Union of India case. It is also called as the first judge's case. In this particular case, the Supreme Court was referring to the term consultation that has been mentioned under Article 124 Clause 2, 217 Clause 1 and 222 Clause 1. 124 Clause 2 deals with appointment of the judges to the Supreme Court, and 217 deals with appointment of judges to the High Court. 222 Clause 1 deals with transfer of judges of the High Court. And in all these cases, the term consultation that has been mentioned in the SP Gupta case, the Supreme Court held that this term consultation, it is not mandatory, but consultation should be effective. That means any advice that is given by the Chief Justice, it is not mandatory or binding on the President to follow that advice, but the whole process should be effective. That means the President, while considering the name of the individual who is to be transferred or who is to be appointed, in that case the President will make all material facts that are available to the President to that particular individual, for that particular individual, it will be made available to the Chief Justice of India. But the President was free to act in a manner that he wanted to, and any advice that was given by the Chief Justice was not mandatory on the President to follow. Clear? Understood this idea? This is what is called as the first judge case, and the ruling of the first judge case is very simple, that the President is the final authority to appoint the judges, whether it is the judges of the Supreme Court, or for that matter, if it is the judge, any judge of the High Court, or when it comes to the transfer of the judges of the High Court, it is the President who does that, and the President will do that in the manner that he wants, though he will consult the Chief Justice of India, but whatever advice is tendered by the Chief Justice, it is not mandatory for the President to follow that advice. It is not mandatory for the President to follow that advice. However, in this case, the Supreme Court also held that though it is not mandatory for the President to follow the advice, but the consultation should be effective. So, the President should make available all necessary facts with respect to those individuals who are being considered for appointment to the Chief Justice of India, CJI. That's it. But under the 1982 case, it was the manner in which the names and the manner in which the President wants to appoint the individual, and not necessarily on the recommendation or on the advice. The advice was not mandatory of the Chief Justice of India. Clear? This was the first judge case. Next. Next paragraph. In the Skara versus the Union of India, Skara versus the Union of India, 1993 case. SCARA means Supreme Court Advocate on Record Association versus the Union of India, 1993 case. The Supreme Court overruled. The Supreme Court overruled its earlier decision. And held that the process of appointment of judges, is an integrated participatory and consultative exercise for selecting the best and the most suitable person, Therefore, the opinion of the Chief Justice, the CJI, the opinion of the CJI shall have primacy. The CJI is the sole authority. The CJI is the sole authority to initiate the process of appointment, of judges to the Supreme Court, appointment of judges to the Supreme Court. He shares this responsibility. With the Chief Justice of High Courts, in appointment and transfer, of judges, of High Court. In the event of any disagreement, in the event of any disagreement between the President and the CJI, Chief Justice of India, CJI, the opinion of the judiciary expressed through the CJI shall be binding on the President, shall be binding on the President. The CJI, while framing his opinion, shall consult at least two of the senior most judges of the Supreme Court, and the process is to be repeated. If the President sends such an advice for reconsideration, after due reconsideration, the advice given by the CJI to the President shall be binding on the President. All such consultation shall be in writing. The Supreme Court also observed that in appointment of the CJI, the President shall follow the seniority principle as far as possible. In brackets write the second judge case. See, the second judge case was a reaction to what Indira Gandhi had done. Though in the 1970s itself, Indira Gandhi had done what? Indira Gandhi had appointed a Chief Justice of India by appointing an individual who was not the senior most judge of the Supreme Court. Till that particular time, there was a convention that was followed. The convention was that the senior most judge of the Supreme Court was to be appointed as the Chief Justice of India. Indira Gandhi bypassed two senior most judges and appointed one individual to be the Chief Justice of India. As a reaction to this particular judgment, the two senior most judges, they resigned from the Supreme Court. This was the first instance wherein it was found that the executive was interfering with judicial matters, because the Constitution explicitly gave this power to the President, that it is the President who will appoint the judges. And though it says aid and advice, consultation of the Chief Justice of India, while appointing the Chief Justice of India, it is completely up to the President. In reaction to this, when we come to the second judge case, in the second judge case, the Supreme Court holds it overruled its earlier decision, which was the first judge case, the SP Gupta, wherein consultation was considered not to be binding on the President. Here, the Supreme Court said what? The Supreme Court said that when it comes to appointment of judges to the Supreme Court, the appointment of judges to the Supreme Court is an integrated and a consultative exercise. It is not a sole authority of the President. It is a consultative and an integrated exercise, an integrated phenomena. And so that the best of the individuals or the best of the talents are appointed to being the judges, the best of the talents are appointed to being the judges, it is mandatory for the President to act in accordance to the advice that has been given by the Chief Justice of India. So, the Supreme Court held that if there is a disagreement, if there is any disagreement between the two constitutional offices, that is the office of the President and the office of the Chief Justice of India, it is the opinion of the judiciary expressed by the Chief Justice of India or expressed through the office of the Chief Justice of India which will be binding on the President. So with this particular decision, what did the Supreme Court do? The Supreme Court took away the power of appointment from the President and gave it to the judiciary. So no more it was the discretion of the executive. It was now up to the judiciary. However, the decision, that is in this particular second judge case, the Supreme Court also held that this particular opinion is the opinion of the judiciary and not the sole opinion of the Chief Justice of India. And that is the reason why, while giving his opinion to the President, the Chief Justice of India will consult two senior most judges of the Supreme Court. And the President of India, if he is not happy with the names recommended by the Chief Justice of India, the President of India, happy with the name that has been recommended by the Chief Justice of India, the President can send such an advice for reconsideration to the Chief Justice. While reconsideration, the Chief Justice will repeat the same process, which means the Chief Justice will consult the two senior most judges of the Supreme Court and then will again tender an advice to the President. And this time, after reconsideration, the advice that is tendered is binding on the President. All such consultation process will be in writing, and while appointing the Chief Justice of India, the Supreme Court in the second judge case held that as far as possible, seniority principles should be followed. As far as possible means sometimes it may so happen that the senior most judge that is there, after the retirement of the current Chief Justice of India, the senior most judge will have only 1 month left. So in that case, he can be bypassed, and the next individual who is the next senior most judge, he is to be appointed as the Chief Justice of India. The Supreme Court also said that while initiating the process of recruitment or while initiating the process of appointment in the as the judge of the Supreme Court in the Supreme Court, in that case, that particular process, it is the discretion of the Chief Justice of India, and he shares this responsibility with the Chief Justice of the concerned High Court, whichever High Court an appointment of judge is to be made. Which means, if you look at the second judge case, in the second judge case, the Supreme Court, the basic idea behind the Supreme Court's decision was to take away this power of appointment of judges, this discretion of appointment of any individual to being the judge of the Supreme Court or the High Court, or with respect to transfer of judges of the High Courts, taking away this power from the executive and giving itself or the judiciary this particular power. Clear? Understood this idea? There is no confusion? Next paragraph. The reappointment of judges case. In the reappointment of judges case in 1998, the Supreme Court further clarified the process of appointment, as it ruled the sole opinion of the Chief Justice of India, CJI, the sole opinion of the CJI does not constitute consultation provided under Article 124 Clause 1, Article 124 Clause 1, Article 217 Clause 1 and Article 222 Clause 1. Write this: Article 124 Clause 2, not 1, Clause 2. Article 124 Clause 2, Article 217 Clause 1 and Article 222 Clause 1. The Chief Justice of India shall consult a collegium of judges. A collegium of judges. COLLEGIUM. Collegium of judges. While forming his opinion. In the appointment of judges of Supreme Court, and transfer of judges of High Court, the CJI, Chief Justice of India, shall consult at least 4 senior most judges. At least 4 senior most judges of the Supreme Court, comma, while appointing judges of High Court, he shall consult at least 2 senior most judges of the Supreme Court. In the transfer of judges of High Court, the CJI should also consult the Chief Justice of sending and receiving high courts. Further, if none of the judges of the Supreme Court consulted by the CJI is next in line to become the next CJI, he shall also consult the judge who is the next CJI. Next paragraph. No opinion that is contrary to that of CJI shall be communicated to the President, Similarly, if two or more judges consulted disagree with an opinion, it shall also not be communicated. To the President. If the President sends an advice for reconsideration, the process will be repeated. All such consultation shall be in writing. The appointment and transfer is subject to judicial review. Only on the grounds that the said procedure has not been followed. See, in the third judge case, that is the reappointment of judges case 1998, the Supreme Court did what? The Supreme Court further clarified how this collegium system would work. And the Supreme Court said, while appointing, the Supreme Court ruled that while appointing the judge of Supreme Court, in that case, the CJI will consult 4 senior-most judges of the Supreme Court. 4 senior-most judges of the Supreme Court. While appointing the judges of the High Court, the CJI will consult 2 senior-most judges of the Supreme Court. Clear? 2 senior-most judges of the Supreme Court. While recommending transfer of judges of the High Court, the CJI will consult 4 senior-most judges of the Supreme Court plus the Chief Justice of sending and receiving High Courts. Which means, if suppose from Delhi High Court a judge has to be transferred to suppose the High Court of Haryana and Punjab, in that case the Chief Justice of the Delhi High Court and the Chief Justice of Haryana and Punjab High Court, they will also be consulted along with the 4 senior-most judges of the Supreme Court. Clear? Understood this idea? See, Article 124 Clause 2 talks about consultation. So, Chief Justice plus Chief Justice of India plus 4 senior-most judges that are there of the Supreme Court, they will consult and recommend who should be appointed to the Supreme Court as Supreme Court judges. When it is suppose appointment is to be done to the High Courts, who should be the judges of the High Court, in that case the Chief Justice of India plus 2 senior-most judges of the Supreme Court, they will be consulted. In transfer of judges of the High Court, Chief Justice of India plus 4 senior-most judges of the Supreme Court plus the Chief Justice of sending and receiving High Courts. Clear? Is this clear? Now, additionally, if suppose in these cases when the judges of senior-most judges of the Supreme Court are being consulted, if it so happens that none of them are next in line to be the next Chief Justice of India. This can also happen. Why? Suppose they are retiring before the retirement of the Chief Justice of India. In that case, it can happen that these individuals are not next in line to become the next Chief Justice. So that judge who is next in line to be the next Chief Justice of India, that individual will also be consulted. Absolutely clear? This is how the collegium system would work.
Next in line in addition to 4?
Yes, next in line in addition. It will always be in addition. If no one is, if the individual is next in line and is the part of the 4 senior most judge, then there is no need for consultation. Only when the out of these senior most judges that are there, no one is to become the next Chief Justice of India. Only then the next Chief Justice of India is also to be consulted. This is how the appointment and transfer of judges, or the term consultation. When we talk about the term consultation, that is mentioned under Article 124 Clause 2, 217 Clause 1 and 222 Clause 1, that is mentioned, it means this. This is under Article 124 Clause 2. This is under Article 217 Clause 1, and this is under Article 222 Clause 1. Clear? Is this absolutely clear? So what does the Constitution say? The Constitution very simply says that to appoint the Chief Justice of India, the President will appoint the Chief Justice of India in consultation with any number of judges that he deems necessary. While appointing other judges of the Supreme Court, the President will consult the Chief Justice of India. But how it actually works? It works through a collegium of judges. This consultation that is there, it is through a collegium of judges. And what is meant by collegium under Article 124 Clause 2, this is what is meant by collegium. Under Article 217 Clause 1, this is what is meant by collegium. And under Article 222 Clause 1, this is what is meant by collegium. Clear? And since 1998, we have been following this very system. This is what is called as collegium system that works in India. Clear? But there have been number of problems with the collegium system. In fact, if you see, there have been number of sitting judges of the Supreme Court and the High Courts, to an extent wherein even the Chief Justice, some retired Chief Justice of India, they have went on record wherein they have said that the collegium system is working. Now the collegium system works how? The collegium system is working through something. Now it is working through something called as preferences. That means the judges that are the part of collegium, they are biased when they are recommending the names of the individuals who should be appointed to High Court and Supreme Courts. And that is the reason why there have been number of cases in which the judges have been accused of corruption. The judges of the High Court and Supreme Courts, they have been accused of corruption. There have also been cases wherein sitting judges have criticized the collegium system. They have said this is a mechanism through which the judiciary, there is, it has become a mechanism of corruption, nepotism in judiciary. Why? Because the judges are preferring their kith and kin over others. So any individual who wants to become the judge of the High Court, if he has what you can say, if he is, he's a relative of these individuals, it is very likely that he gets appointed to being the judge of High Court and Supreme Courts. Why? Because he has individuals within the collegium system. To an extent wherein it has also been seen that some of the judges who have been appointed to various positions, they have been alleged of various phenomena also. Like recently a judge, now when I say recently, around 3 to 4 years ago, there was a case that appeared. It was it was nationally talked about, and it also became a debate on collegium system, wherein one of the judges of, I think it was the MP High Court, he was alleged to have sexually harassed a women lawyer, and she openly in the media said, from today I am going to give up my practice of this this practice as a lawyer, because I have been frequently harassed sexually harassed by this judge, and when I have tried to complain, there have been no action against the judge. She went on the national media to accuse the judge, and that again raised a question about the effectiveness of the collegium system. It was nepotism. There have been number of cases in which, there was a case in which previous, I think it was Y.V. Sabrawal or something, previous Chief Justice of India was alleged of corruption. Similarly, if you look at the recent Chief Justice, who very recently retired, Ranjan Gogoi, he was alleged of again sexually harassing one of the lawyers. Not just that, to an extent wherein the Chief Justice of the Jharkhand High Court, she said that because of this collegium system, there have been very less appointment of women as judges of the Supreme Court. In fact, if you go, if you see the history in terms of how many judges have been appointed to the Supreme Court, how many women judges have been appointed to the Supreme Court, you will find it is only 1 or 2. She blamed, before she was appointed, she was appointed to the Supreme Court also. She was the Chief Justice of the Jharkhand High Court. She was appointed to being the judge of the Supreme Court. But before her appointment, she had criticized the collegium system. She said that it is because of this that women judges are not appointed to the Supreme Court. Why? Because it is dominated by male, and they do not want women judges in the Supreme Court. The collegium system in India has undergone a lot of criticism. It is something that that has raised a concern, and this concern was answered by the last government, when in 2015 they amended the constitution and added Article 124A of the Constitution, which talked about a body called as the National Judicial Appointments Committee. National Judicial Appointments Committee. This body was recommended by the Second Administrative Reforms Commission. Now, they recommended a committee to take up appointment of judges, which was very similar to the NJAC. Who were the members of NJAC? The Chief Justice of India was the chairman. The Chief Justice of India was the chairman of the NJAC. Then there were members, the law minister, the law minister. Then there were 2 Supreme Court judges, 2 Supreme Court judges and 2 eminent jurists who were to be the member of NJAC. How were these 2 eminent jurists to be appointed? They were also to be appointed by a committee on the recommendation of a committee which was to be headed by the Chief Justice of India. The members of the committee would be the Prime Minister of India and leader of opposition in the Lok Sabha. So these 2 eminent jurists were to be appointed by a committee, Chief Justice, Prime Minister and the leader of opposition. Through this particular committee, these 2 eminent jurists were to be appointed. 2 senior most judges of the Supreme Court along with the Chief Justice of India who was to be the chairperson of this particular committee, and the law minister of the country. The Supreme Court declared this to be encroachment on the independence of the judiciary, thereby declaring it to be unconstitutional. Encroachment on the independence of the judiciary. The Supreme Court said this because you can see the fundamental problem with this was inclusion of the law minister and 2 eminent jurists. They were the bench that heard the constitutional matter. They were of the opinion that through the position of the law minister and 2 eminent jurists, the executive will enjoy control. The executive will enjoy control over the whole procedure, and that is what was viewed as encroachment on the independence of the judiciary. This was what was viewed as the encroachment of the independence of the judiciary. Therefore, NJAC was declared to be unconstitutional. The Supreme Court did not disagree. When the Supreme Court was constitutionally hearing this matter, this constitutional case, the Supreme Court did not disagree that there are some problems with the current collegium system. The Supreme Court did not disagree with that. The Supreme Court was very much of the opinion that yes, there is a need for a reform. But the Supreme Court said that this reform could not be through the NJAC. There is much more than just an NJAC which can be introduced for reforming this very idea. And that was the reason why NJAC was declared to be unconstitutional. Clear? Now, have you understood this whole process? Recruitment, the appointment of judges, have you understood this whole process? Because you have said that you have understood this process, what is the fundamental problem that you see when it comes to the collegium system? Legally speaking, what is the fundamental problem that you see with the collegium system? What are the merits of the judges? See, actually there is no such thing as contesting for a particular position. Here the name, everything is completely, who is to be appointed, it is completely. It's not like an individual can choose, or an individual can apply to this position. That is not something that happens. On what criteria? Okay, yes, this definitely can be one reason. Yes, the transparency, yes, See, the judge who is being transferred, how that will not be a valid idea. If you are asked whether you want to be transferred to a particular position, you might not necessarily accept it. In fact, there was a case itself wherein the Kolkata High Court judge, when he was transferred to another High Court, he refused that transfer, because of which he was punished for contempt of court also. But that will not be a valid ground. But what both of them are saying, it is very much valid. See, if you look at how this process of collegium is working, the Chief Justice of India, 4 senior most judges, they are giving a particular, they are advising the president on a particular individual's name. The question is, what is the objective criteria that the collegium has considered? There is no objectivity to it. It is completely dependent upon the collegium. So they are, it is like a discretionary power that they are exercising without any check, because the process is not transparent. The process is not transparent. Yes, it can be challenged, but what is the ground on which it can be challenged? The Supreme Court itself says the ground is what? The ground is if the procedure has not been followed. You cannot challenge the name of the individual. You can only challenge if the procedure has not been followed. If we look at this particular idea, we find that the whole process can be absolutely arbitrary. The whole process can absolutely be arbitrary. An individual who is being appointed to the Supreme Court only requires what? Only requires that there should be the Chief Justice of India, and there will be at least 3 judges if they agree to their name. Out of the 4 judges that have to be consulted, if 3 judges are agreeing to the name of one individual and the Chief Justice agrees to it, the individual will be appointed. This process can be absolutely arbitrary in nature, without looking at the merit that the individual holds, without scrutinizing the decisions that the individual has given. So there is no objectivity and no transparency, as she says. No objectivity in what criteria you have considered to appoint, to see the name of the individual, as well as what is the manner in which you have excluded others from this particular name. How have you excluded others? What is the objective criteria? And while discussing this, what were the decisions, or what were the opinions of all of these judges? There is no transparency to it. There is no transparency to it, and that is the reason why we see these problems. The problems of arbitrariness, the problems of individuals getting appointed to being the judges of the high courts who do not deserve such an appointment, who may not necessarily deserve such an appointment, because when we talk about seats of justice, whom do we want to occupy such seats of justice? Those individuals who are of a certain kind of character, and they have in their previous experience given a certain kind of judgments. We want those individuals to be appointed. But what is happening here? The appointment that is being done, it is completely up to the collegium, and no one can challenge this very appointment. This lack of transparency and the lack of objectivity is the fundamental problem. It is the fundamental problem with the existence of the collegium system. Clear? Lack of objectivity and lack of transparency. And that was the reason why this was included. But the judiciary disagreed with this. Why? Because according to the judiciary, this was an encroachment on the authority of the independence of the judiciary, which actually is not true. But because it was a decision of the court, and there was, Arun Jaitley, who was then the finance minister, he very much criticized this decision of the court. He said that NJAC while declaring that this is an encroachment on the independence of the judiciary. How come it is an encroachment on the independence? The Chief Justice of India is the chairman of the NJAC, and if you look at how it was to work, it was explicitly mentioned, any decision which was contrary to the decision of the Chief Justice will never be referred to the President. So how come it could have been an encroachment when there is already the Chief Justice and he is the final say with respect to appointment of judges? He will be the one who will recommend the names to the President, and if he does not agree to that name, that name will not be considered by the President. Similarly, there were two senior most judges also. So, and it was said that any opinion of the NJAC will not be contrary to the opinion of the judges. So, how can it be an encroachment on the independence of the judiciary? And Arun Jaitley was a vocal critic of this particular decision. But when you look at the judiciary, the Indian judiciary suffers from this very problem. What is the problem? It is oversensitive when it comes to its own issues. It is oversensitive when it comes to its own issues. It will, the Indian judiciary is ready to challenge each and every institution in India, the decisions of the Prime Minister, the decisions of the Council of Ministers, the decisions of the legislature. They are very much, they are very much liberal about challenging such decisions. But when it comes to the judiciary, when it comes to looking inside them, now they become oversensitive then. So they do not recognize that lower judiciary today is the hub of corruption in India. The corruption that exists in lower judiciary does not exist anywhere else. Not even in administrative, not even in political corruption. It is not as huge as the lower or the subordinate judicial process that is there. But you will find that the judiciary is not very much. The judiciary, there the Supreme Court has nothing to say. There the High Court has nothing to say. But when it comes to black money, you are ready to form an SIT on it. This is not your job. That is not judiciary's job to form an SIT on black money. That is executive's job. Or the legislature, if they want, they can come up with a law on it. But there is no such thing. No interference should be there from the judiciary. But what does the judiciary do? The Supreme Court has an SIT. The Supreme Court has an SIT. An SIT was formed on black money, and it was asked how much black money is in existence in India. And they replied, what was their answer? From 7% of India's GDP to 126% of India's GDP. Anywhere between this. The SIT replied in this particular manner. So the judiciary is very much ready to form an SIT on black money, but not when it comes to coming to check the judicial corruption that is there. And this is the problem that we see here. This is the problem that we see. See, we do not completely disregard the fact that the existence of law minister could definitely have been influential here. But what we also need to look at is the spirit of the Constitution. And the spirit of the Constitution dictates that it will be the President who will appoint. And nowhere it talks about a collegium system. So rather than having an unconstitutional body taking up the decisions or to be included in that consultation process, at least we should have a constitutional body looking into it. And because there was even a check, even if the law minister was involved, there was a check because of the 3 judicial members. So the law minister could not have dominated the process. But the judiciary declared this to be unconstitutional. So this is the problem with the judicial system, how it works, and the problem with the what you can say, the process of the collegium system that is in existence. There have been number of criticisms, and this is not new. This criticism, see, collegium system came into being like what we have read after the 3rd judge case, which means in 1998. And since 1998, which means it has been more than 22 years. It has been more than 22 years that we have been actually following the collegium system. And if you look at over this 22 years, number of problems or number of cases wherein the collegium system has been criticized for or has come into being for whatever reasons, there have been number of such cases. But the judiciary has, no, it is hell-bent not to reform itself. And that is the reason why they disagreed with such an idea. Clear? This is appointment of judges. See, not only have we discussed the appointment of judges to the Supreme Court, but we have also discussed the appointment of judges to the High Court and the transfer of judges in the High Courts. Clear? So, I am not going to anymore discuss Article 217 and Article 222 because we have already seen what it is all about. Clear? Next, give a subheading, right? Removal of judges. Removal of judges. It's very important. Very important. Last year, 2019 prelims examination, there was a case. No, there was a question that was asked here. Yes. It is. See, impeachment of judges. Use of term impeachment here is wrong. The newspapers, in newspapers you have read this particular idea, impeachment of judges, but technically it is not correct. Technically it is not correct. In India, the newspapers, that the manner in which we follow our journalism is more Western oriented, and you will find all these national newspapers, they tend to have a Western way of writing things, and in Western countries it is the term impeachment is used. In India, technically speaking, it is not impeachment, it is removal of judges.
So why then use this term?
See, it is a very loosely used term. Technically speaking, it is removal, it is not impeachment, because impeachment is a legislative process. Here the final authority lies with the executive, not the legislature. So we cannot consider it to be truly an executive, legislative process. So technically speaking, it is removal, not impeachment. Constitutionally speaking, it is removal, not impeachment, because Constitution nowhere mentions impeachment of judges, it mentions removal of judges. It talks about impeachment only in the case of president. Clear? Removal of judges. It's a very important idea, because last year there was, going back to the time when Deepak Mishra was the Chief Justice of India. So there was a process that was initiated by the opposition party in the Rajya Sabha, which was to remove the Chief Justice of India. It was rejected by the chairman of Rajya Sabha, Venkaiah Naidu, Vice President. He rejected it. But there was a process that was initiated. And what was that process and how it works, we are going to see as of right now. First, let us discuss what the Constitution has to say about it. And the Constitution, under Article 124, write this, under Article 124 Clause 4, under Article 124 Clause 4, a judge of the Supreme Court can be removed. A judge of the Supreme Court can be removed by the President, upon an address by both the houses of the Parliament, by a majority of not less than 2/3 members present and voting, not less than 2/3 members present and voting, and by a majority of the total strength, of the House on the grounds of misbehavior and incapacity, on the grounds of misbehavior and incapacity, the President shall pass the order of removal. The President shall pass the order of removal in the same session, order of removal in the same session in which the Parliament has passed the resolution, in which the Parliament has passed the resolution, underline misbehavior, incapacity, underline misbehavior and incapacity, and underline this last point, that is in the same session, in the same session. Clear? So if you look at Article 124 clause 4, it says, first of all, it lays the grounds of removal. And what is the ground that is mentioned? It is misbehavior or incapacity. Clear? These are the two grounds that have been mentioned. How is this misbehavior and incapacity established? When both the houses of the Parliament passes a resolution by a special majority, the majority that you have mentioned, at least 2/3 members present and voting, and underline that and also. It's not or, it is and, which means 2/3 members present and voting plus a majority of the total strength of the house, which means more than 50% of the members of the total strength of the house. If they pass the resolution and the President signs, President signs the order of removal in the same session, which means if it has been passed in the budget session, so in the budget session, if it has been passed in the monsoon session, in the monsoon session, that very monsoon session, and if it has been passed in the winter session, so in that very winter session, or if suppose there has been a special session that has been called, and in that very special session, if the President has signed the order of removal, then the judge will be removed. Clear? Next paragraph. Under Article 124 clause 5, under Article 124 clause 5, the Parliament has enacted the Judges Inquiry Act, of 1968, in 1968, to regulate the procedure for presentation of an address, and for investigation to prove misbehavior or incapacity. Before actually writing anything further, just understand this. Article 124 clause 5 says that it is the Parliament of India which has the authority to regulate how this misbehavior or incapacity can be established. So who has actually done this? It has been empowered. The Parliament has been empowered under Article 124 clause 5 to decide how this misbehavior or incapacity has to be established. And accordingly, the Parliament has passed what? The Judges Inquiry Act of 1968. The Judges Inquiry Act of 1968. Clear? Now, before you write anything, just understand what is mentioned in the Judges Inquiry Act. The Judges Inquiry Act says that when a resolution has been introduced in any of the houses of the Parliament to remove the judge of the Supreme Court, it has to be introduced in a certain manner. What is that manner? If it is introduced in the Lok Sabha, it requires the support of at least 100 members. If it is introduced in the Rajya Sabha, it requires the support of at least 50 members. If the presiding officer is satisfied, see what does it say? If the presiding officer is satisfied with its introduction, the presiding officer would establish a 3-member judicial committee. The presiding officer will establish a 3-member judicial committee, and it will be this judicial committee which will investigate misbehavior or incapacity. Who will be the members of the judicial committee? 3 members. There will be a sitting judge of the Supreme Court who will be the chairman of the committee. Then there will be a sitting judge of either one of the high courts or Supreme Court, or the 3rd member will be an eminent jurist. So the sitting member of a sitting judge of the Supreme Court will act as the chairman. Then there will be a sitting judge of either a Supreme Court or the High Court, and the 3rd member will be an eminent jurist. And who will establish this committee? The presiding officer of the house in which this resolution has been introduced. The presiding officer will establish that particular committee. The committee will do what? Investigate. The committee will report to the presiding officer, and in light of the report that is submitted by this particular judicial committee, voting will be done in the parliament. We have already seen what is the kind of majority that is required. Clear? So what happened? Deepak Mishra, he was the opposition party had alleged that Deepak Mishra is trying to do what? That Deepak Mishra has taken upon himself all the important cases that are there, that are pending in the Supreme Court, and he's acting as, because he's the Chief Justice of India. If you look at the parliamentary, if you look at the constitutional provisions, it says it is up to the Supreme Court, and the Chief Justice decides how he wants to allocate whatever cases that are there in the Supreme Court, what benches are allocated with those cases. It is up to the Chief Justice of India. He makes that allocation. And the opposition party had argued that Deepak Mishra is misusing his position to allocate these important cases to himself. When this resolution was introduced in the Rajya Sabha, because in the Lok Sabha the opposition party, that is the Congress party that is there, they may not necessarily, they did not have that 100 members who would support it. So they wanted to introduce it in the Rajya Sabha. When it was being introduced, Venkaiah Naidu rejected it. He said no. Why? Because it can be introduced only on the satisfaction of the presiding officer. If the presiding officer is satisfied, only then he will introduce it and then establish a 3-member committee. The presiding officer was not satisfied, he rejected it. It was not introduced in the Rajya Sabha. Clear? So it is completely up to the presiding officer. The Judges Inquiry Act. Understood this idea? And this was the question that was asked. The Judges Inquiry Act of 1968. This was a question that was asked in 2019 prelims examination. Clear? Write down. Under this act, if the resolution is introduced in the Lok Sabha, if the resolution is introduced in the Lok Sabha, it shall be supported by not less than 100 members of the Lok Sabha, not less than 100 members of the Lok Sabha, and in the Rajya Sabha, at least 50 members of the Rajya Sabha. At least 50 members of the Rajya Sabha. If it is properly introduced, the presiding officer of the House shall appoint a 3-member committee. Shall appoint a 3-member committee. 3-member committee. The chairman shall be a sitting judge. The chairman shall be a sitting judge of the Supreme Court. Supreme Court. The second member is a sitting judge of High Court or Supreme Court. Of High Court or Supreme Court. And the third member is an eminent jurist. The committee thereafter submits a report to the presiding officer. Clear? This is what is mentioned under the Judges Inquiry Act. We have almost completed the removal process. I'll stop here today because I have to deal with a case that has happened on the Judges Inquiry Act. This law was also challenged. And what was the decision of the Supreme Court there? We are going to tomorrow when we meet. First of all, we look into that. And then we move to, with this we have completed our our discussion on appointment of judges and removal of judges. And then we move to the jurisdiction of the court. So we are going to look at Article 131, 32, 33, 144, 143 of the and 142 of the Constitution. We are going to look at these provisions. With this we complete our discussion on the Supreme Court. Clear? Thank you.